WRITS are among the most powerful constitutional remedies, but real key for competitive exams is not only knowing when a writ is granted, but also understanding when the courts refuse to grant it. Therefore, in today's video, we will discuss in a simple and exam-oriented manner the conditions for granting and not granting all the 5 writs. Writ number 1, that is habeas corpus. Habeas corpus literally means to have the body. It means that a person imprisoned or detained by the law can inquire under what authority he has been imprisoned or detained. The court issues the writ against the authority concerned. If the executive arrests someone without the authority of law or in contravention of procedure established by law, so the purpose of this habeas corpus is to protect people against illegal detention. When this habeas corpus will be issued? It will be issued when a person is unlawfully detained. And when it will not be issued? Number 1, if detention is lawful, it will not be issued. If detention is under valid court order, it will not be issued. And number 3, if person already released, then it will not be issued. Thus, illegal custody is equal to habeas corpus. Number 2, writ number 2, certiorari. Certiorari is a command or order to an inferior court or tribunal to transmit the record of a cause or matter order passed by it to superior court. So, certiorari is a writ by which the superior court calls for the record in which order has been already passed by the inferior court or tribunal. Now, the question is, who may apply for the writ of certiorari? See, in the case of Chiranjeev Lal, it was generally stated that except in the case of habeas corpus, none but the person whose rights have been affected, that is aggrieved person, can apply. What are the grounds to grant certiorari? The grounds to issue certiorari is number 1, lack of jurisdiction, number 2, excess of jurisdiction, number 3, abuse of jurisdiction, number 4, violation of principle of natural justice, number 5, error of law apparent on the face of record, and number 6, fraud. Certiorari will not be issued under these conditions. Number 1, against administrative decision, number 2, against private bodies, number 3, when the order is not final, number 4, to correct factual errors, and number 5, when an alternative effective remedy is available. Number 3, writ number 3, writ of prohibition. The writ of prohibition is available only when the inferior court or tribunal has not made a decision, that is, in pending cases. But if the court or tribunal has made a decision, in that case, writ of certiorari will lie. The writs of prohibition and certiorari are issued at different stages of the proceedings. When an inferior court takes up a matter against a person over which it has no jurisdiction, the person so affected may move to Supreme Court or the High Court for the writ of prohibition. On the other hand, if the court hears that case and gives a decision, the party aggrieved will have to move for a writ of certiorari for quashing the decision. Writ number 4, that is writ of mandamus. The writ of mandamus is a command. It is a residuary remedy. It is issued by the Supreme Court or the High Court against a government, court, corporation, or public authority to do or forbear from doing some specific act. Condition for granting of writ of mandamus: number 1, to enforce a public duty, number 2, against government and statutory bodies like government departments, public officials, municipal authorities, and statutory corporations. When there is a legal right, the petitioner must show that he has a legal right which is being denied. Number 4, when there is a failure of justice. Now, when mandamus will not be issued? It will not be issued against private individuals or private bodies. Number 2, when the duty is discretionary. Number 3, against the president or governor, mandamus will not be issued. And number 4, when an alternative remedy is available, if appeal or revision is available, court generally refuses mandamus. Number 5, writ of quo warranto. Quo warranto means by what authority? It is issued by the Supreme Court or the High Court to question the legality of a person's claim to a public office. When quo warranto is issued? When a person holds a public office illegally. If someone occupies a public post without fulfilling eligibility conditions. And number 2, when the appointment violates statutory provisions. Number 3, no need to show personal injury, because any citizen can file this writ even if he is not personally affected. And when this quo warranto will not be issued, it will not be issued when the office is private, when the person is legally qualified. Number 3, when the office is not created by law. Number 4, for purely temporary or contractual post. Number 5, when the person has already left the office. The quo warranto checks illegal holding of a public office. These 5 writs form the backbone of constitutional remedies, ensuring justice and control over unlawful actions of authorities. If you clearly understand when each writ is issued and when it is not, you will be able to answer most UPSC and judiciary questions confidently. Keep revising, stay connected, and we will continue simplifying the Constitution together.